To the Honorable Rick Brewer, Chairman, and members of the Hawkins County Board of Commission in regular session met this 25th day of January 2021. Resolution in support of Drug Dealer Liability Act lawsuit. Hawkins County Legislative Body meeting in regular session on 25th day of January 2021. A quorum being present, majority voting in the affirmative, hereby resolves as follows. Whereas Hawkins County, as well as other counties in Tennessee and in surrounding states, has experienced an epidemic related to the distribution and use of opioids by its citizens that has generated critical issues and problems for Hawkins County, including but not limited to opioid addiction by Hawkins County citizens, drug overdose deaths, the birth of drug-dependent babies, a rise in criminal charges, convictions for the illegal sale and use of opioids, as well as other crimes resulting from the opioid abuse epidemic, including but not limited to burglary, theft, and fraud, and the lost productivity of the citizens in the workplace, damage and destruction to the family unit, all resulting from the illegal sale, distribution, and use of opioids in Hawkins County. Whereas District Attorney Dan E. Armstrong is the duly elected District Attorney General for the 3rd Judicial District of the state of Tennessee, whereas General Armstrong brought a lawsuit in 2017 through the firm of Branstetter, Strange, and Jennings, PLLC, to recover money for Hawkins County under Tennessee's Drug Dealer Liability Act, otherwise known as DDLA, and that lawsuit is pending Hawkins County Circuit Court. Hawkins County Commission hereby resolves that it fully supports the lawsuit, approves of the actions taken in the lawsuit thus far on its behalf, approves of the lawsuit going forward with Hawkins County as the named plaintiff, and retains District Attorney Armstrong and the law firm of Branstetter, Strange, and Jennings, PLLC, as counselor in this matter. Upon approval of Resolution 2020-0103, also approved is the attached retainer agreement between Branstetter, Strange, and Jennings, PLLC, and District Attorney Dan Armstrong, 3rd Judicial for Hawkins County. Mr. Chairman, I so move.
Motion by Commissioner DeWitt, second by Commissioner Kern. Is there any discussion?
We have a representative here that could answer any questions from the statement.
You wish to be recognized, Ms. Jessica?
Yes, do you have another representative here?
No, that's you.
Okay, I am not part of that lawsuit. I do not want you to vote for that. I represent the county in the current lawsuit. That lawsuit will do nothing but harm the county. We actually told Mr. Strange that in 2017 when we came here. And we told General Armstrong that he could not go forward as he did. You all voted to go with us. We have filed the lawsuit on behalf of you in federal court against the distributors and the manufacturers. I have to apologize. We have sent letters to the county mayor. I did not realize those had not been shared with you. So the first thing I want to do is the last letter we sent out was in regard to Mr. Armstrong's lawsuit, and we told you in December of 2017 that we need to come, December 18, 2020, that we need to come meet with you because there's settlement negotiations. I cannot speak about that publicly. However, in the letter to the county mayor that was emailed and mailed and 2 phone calls were made, we asked to go into closed session. I need to meet with you sometime before June to discuss our lawsuit. I will distribute a copy of the letter that I sent directly to the county mayor. From this point forward, I will continue to send letters directly to the county commission. So if I may enlist the help of the sheriff, please take a copy of the letter. If there's any extra, I know some of the commissioners asked that I leave them at Ms. Davis's office that are not here so they could pick them up. As to this resolution, we ask you to vote no. As I said, in 2017, we told Mr. Armstrong that he could not prevail on this case. In December of 2020, they dismissed his lawsuit. That is what you're getting, is the order from the Tennessee Supreme Court dismissing the lawsuit. So what they have now done is went to 13 of our counties that we represent asking for you to sign this contract. We told them in 2017 they need to approach us. They did not. Last Thursday, Mr. Strange called our firm's group and asked that we allow them to do this. We told him today and sent him a cease and desist letter to specifically tell him to quit soliciting our clients. We represent you. We have filed the exact same cause of action. And to make sure there is absolutely no question, my contract got signed and it was voted on in 2017, approved in 2018, and we filed in 2018. I sent a copy of the lawsuit to the county then, and our lawsuit, which I brought a copy of the front page today, as you can see, we represent Hawkins County. I have highlighted, and this is important, Mr. Stranch wants to sue Purdue Pharmaceuticals, Endo, and Mallinckrodt. We have already sued them for you. I will let, if the sheriff will help me again to distribute copies of this, because I want you to understand that as to their lawsuit, two of those individual manufacturers, being Purdue and Mallinckrodt, are in bankruptcy. They are in bankruptcy in the state of New York. We have had to pay to hire an attorney in the state of New York on behalf of Hawkins County to file a claim in the bankruptcy. He is only left with a lawsuit against Endo. The state Supreme Court told him he cannot go forward as to the counties. So Mr. Stranch has now lost. He stood in front of Hamlin County and told Hamlin County he's put millions of dollars in the case. I do not doubt that. But the problem is, as a trial attorney, you know sometimes you win and sometimes you lose. He lost. Now he's coming to the counties and he's asking you to allow him to go forward and also be your attorney. So I submit to you today, why would you do that? You are under contract with us for 30%. He has submitted a contract to you for you to hire him to go against Endo. We think the contract's not specific, and I'll get into that in a minute, and to represent you against Endo, and he wants 25%. So we're in negotiations with Endo. Let's use ballpark figures. If we get you a settlement of $100,000 and you sign this contract with him, you'll give us 30%, which is $30,000, then you'll give him 25%. Why would you hire two firms to pave the same road? Let us do the work and let him sit over there and get 25%. That doesn't make sense to me. The other thing that doesn't make sense to me is I went through all the committees I had to go through to get the county's approval. I came here first. This is my home. This is where I live. It meant something to me. I had to change our contract for Hawkins County very specifically. In my contract, which is almost 7 pages, we agreed not to sue local pharmacies. We agreed that if there was any cross claims or counter claims, that we would indemnify the county. None of that's in his contract. And more notably, I have the email from 2018 that he sent to your county attorney and copied Dan Armstrong on and said, if I represent your county, I'll only charge you 20%. Yet in this contract that is 1 page today, it says 25%. So I don't know why today we would go forward and sign this contract with somebody that's already lost and waste even more money for the county. The other thing that's not mentioned in the contract, all these fees that he's incurred up until this point, guess who's going to have to pay for that? The citizens of Hawkins County. Now, we've done the same lawsuit. We've already pulled all the same discovery. We've gotten all your information. Why would we pay him for fees on a lawsuit that he's lost just to start over again? So I'm not surprised that he's not here today, because we did send a cease and desist letter asking him not to try to poach or solicit our clients, because we have the identical lawsuit in federal court. However, I will tell you, we are asking you humbly to not vote for this, because if you do, it will do nothing but complicate your lawsuit that's in federal court right now. You all have any questions?
Mr. Chairman,
Mr. DeWitt.
I just want to state that, I was just asked to read this. This is new information to me and really shouldn't have been. I should have gone back and looked at that. I'd like to ask Mr. Phillips what his opinion is on this.
Well, I got this agreement and was asked to submit it to a resolution, which I did, after which I heard from Mrs. Jessicburg that they wanted to speak to the court and the commission and object to it on the basis that we'd already signed a contract with them. In my opinion, probably the best procedure at this point would be to withdraw, pull, or otherwise table this until we could give it a little bit more review than we've been able to until now.
Mr. Chairman, I'm gonna pull this resolution.
Thank you, Mr. DeWitt.
I do need to say, I have to meet with you in closed session. I know we're having technical difficulties with Zoom, but sometime in May or June, we have to meet. So if you will get with your county attorney and let us know, we will come back and meet with you, but it absolutely is gonna be upcoming.
Ms. Jesse,
Yes,
I will ask if you don't care, reach out to us. You've obviously reached out, like you said, and it didn't get passed on to us. And it's information that we need to know, so, and that's not your fault, not your fault at all. So I ask if you reach out to somebody on this board, the public safety chairman, or personnel, or budget, or whoever, don't mind any of us.
I do.
We would inform the rest
All
of
of
us.
us. Just
Like,
all
all
of
of us, that
us.
was not your fault at all. So I want you to know this is not your mistake.
it is. I should have known better, but I will. I will reach out to every one of you, so I really appreciate that. Thank you.
Thank you, Mr.